So there was a decision in a Seattle state trial court on Friday involving Initiative 2066, which protects natural gas in Washington state for homes or businesses. The radical environmentalists don't like Initiative 2066, and they've said from the beginning that they opposed it. Now it passed by a vote of the people last November, about a 52-48 split, and the really far left environmental groups immediately started moving toward a lawsuit. And that's what happened on Friday, the culmination, at least the first stage of deciding that lawsuit. Critical to the whole process was a letter written by a group called the Pacifica Law Group, a law firm that does environmental advocacy and other left-wing advocacy. They sent this letter to then State Attorney General Bob Ferguson right after I-2066 was passed into law, making the case for why they thought it was a bad initiative, claiming it violated the single subject rule, it dealt with more than one subject at a time, claiming that the title was confusing. These are traditional claims that left-wing groups make against populist initiatives. That letter essentially is the opinion that this trial court judge, Widlin, made on Friday. She basically is parroting almost word for word the content of the Pacifica Law Group letter from last November. It might have been December. And it's clear that this lower court opinion on Friday, the fix was in. None of the complicated filings and legal processes and exhibits factored into the ruling. That one letter from last year clearly is what shaped the ruling. There's been a lot of questions raised too about this lady judge's political contributions. She has a long history of making left-wing political contributions to people like Jay Inslee, Bob Ferguson, Manka Dhingra, Dow Constantine, kind of the murderer's row of left-wing politics in Washington. Some people have said she should have recused herself from this case because of her close political ties with Inslee and Ferguson and Constantine and others. The rules around recusal, when judges recuse themselves, are not written in law. Those are ethics rules that judges and lawyers follow. And I'll leave it up to others to comment on whether her not recusing herself, her making this ruling in this case, where she clearly has a partisan bone to pick, was right or wrong. But I'll say this much, it's a bad optic. It's a bad image that someone so partisan is ruling on a controversial issue. Making the bad optic worse, Jay Inslee was in the courtroom on Friday when she issued Pacifica Law Group's opinion in the case. That's a bad optic, and I wasn't there, but I'm told they sort of nodded to each other and wink, wink, and did this kind of stuff. That's not great. There will be an immediate appeal to the state Supreme Court on this matter, and I hope that the judges on the state Supreme Court take into consideration the tainted nature of this ruling on Friday, really written by Pacifica Law Group and channeled through a politically partisan judge. The reason these ethics rules about recusal are on the system, in the books for judges, is to avoid the appearance of impropriety or conflict, which undermines everyone's confidence and trust in the court system. This Judge Widlin, she's making that problem. She's encouraging distrust in the court system, and I hope the state Supreme Court keeps that in mind when it considers this case.